We know that these are difficult and trying times for both debtors and creditors alike. The new insolvency regime, introduced in January 2015, was put in place to provide rescue opportunities for debtors. One of the important benefits that the insolvency regime made possible for debtors was that it allowed debtors some breathing room. It allowed a stay of action to be automatically put in place.
Yes, there's an automatic stay of proceedings once a proposal is lodged. However, that stay can be lifted if it is discovered that the debtor has not made the requisite disclosures, is not acting in good faith, or is not acting fairly towards the creditors.
You will not need to get every single creditor to agree to the proposal. If the proposal is agreed by the required majority and approved by the court, then it will be binding on all unsecured creditors and on all secured creditors to whom the proposal was directed.
Hilary mentioned that not all creditors need to agree to the debtor's proposal. Creditors have the opportunity to have their voice heard. A creditor can put forward evidence of the viability and genuineness of a debtor's proposal, and this evidence is considered at the meeting where the creditors will determine whether they agree to the proposal.
Few words of caution, however. The rescue mechanism under the insolvency regime is a way to come up with a workable arrangement with your creditors. If that effort fails, either because the creditors do not agree or because you fail to carry out the proposal which has been agreed and accepted, then that will lead to insolvency.
All creditors, whether secured or unsecured, have rights once the insolvency process is initiated. A debtor is always being scrutinized and he must act in good faith. Good faith means that the debtor must act with commercial fairness and must give full and frank disclosure of all its assets and liabilities to all the stakeholders involved in the insolvency process. The insolvency legislation affords an opportunity to debtors to restructure their affairs. However, the rights of the debtor must always be balanced with the right of the creditor once the insolvency process is initiated.
So, to maximize your opportunities under the insolvency regime, speak early and speak openly with your creditors.